Thank you for asking the Canadian Environmental Law Association to provide some background on Canadian water legislation, and we're going to provide an overview and some stories talking about how we developed the water law we have here as we go through the slides. Next slide. And we'll be talking about the Canadian Environmental Law Association, so you know who we are, a little bit about how we look at environmental issues from an equity framework, the water law framework that we're working with jurisdictionally, and a case study focused on the tragedy in Walkerton, Ontario from the year 2000. Next slide. So the Canadian Environmental Law Association is a specialty legal aid clinic funded by Legal Aid Ontario, along with a number of other community legal clinics in different areas of the law in Ontario, working on provincial cases and also national law as well as provincial law. We are dedicated to environmental equity, justice, and health, and our services are available free of charge to qualifying low-income and vulnerable or disadvantaged communities in Ontario. We also advocate for their right to better protect the environment and the communities they live in from environmental hazards. Next slide. One of the areas we focus on is the issue of equity across all of our work. And in terms of water, we looked a number of years ago at the issue of high volume discharge of pollutants into various media in the Great Lakes Basin and issued a report. And we found that more than 1 billion kilograms, or about 25% of the total air pollutants reported across all of Canada, were being released to air in 2005 in the Great Lakes Basin, and we'll shortly be updating these statistics with a new report. Those varied widely across the Great Lakes, and we found that there were 37 specific areas within the Great Lakes Basin that had both high reported air releases of toxic pollutants from those large facilities, as well as high poverty rates. That means that people living in those areas have a double challenge. They have the high potential for exposure to those pollutants, many of which included carcinogens and other neurotoxic and other health impacts. And then they're also contending with the physical and social vulnerabilities that come with poverty. Next slide. So turning for your purposes to the framework we're working with in Canada, it's important to know that we have a number of sources of law in Canada. We have the common law that was introduced from the United Kingdom and continues to develop across the common law legal world. We have statute law legislation, so the legislature of the province or the Parliament of Canada adopts a statute and specifies the purpose and operation of the law. We have Indigenous law as well. And then we have the Constitution, which was repatriated to Canada in 1982. And I'll talk about that a little bit more in a second, as well as a concept that decision making in Canada, provincially and federally, must accord with the rule of law, must not be arbitrary. And we are a federation, so that's a distinction from the US context. And we have a different division of powers between our federal pan-Canadian framework and each of the provinces and territories. And that's specifically listed in the Constitution that was established in 1867. And there was a list of powers in each area, and then some catch-all powers like things that are necessary for peace, order, and good government. But water, as well as environment more broadly, is not listed in the constitutional document. As a result, water management and water regulation, as well as environmental regulation more broadly, is shared between the Federation embodied in the Parliament and each of the provinces and territories within their own boundaries. Next slide. So in terms of the federal authorities that are enumerated in the Constitution Act, powers that are related to water, among many other powers that we're not getting into today, include federal powers related to sea coasts. Canada has 3 oceans on its borders, powers related to fisheries, powers related to navigation, including inland waters, powers related to indigenous peoples and lands, the criminal law power, which interestingly often applies to environmental law, as well as this broader peace, order, and good government provision, which is also a way that additional powers can be exercised or taken on federally if they weren't originally seen that way. And then certain authorities are delegated to the territories, like the Yukon, Nunavut, Northwest Territories. And finally, the federal government, in its water powers, can set water quality objectives and guidance, and I'll talk more about that momentarily. And then on the provincial side of that constitutional document from 1867, the powers that relate to water in one way or another include powers related to provincial public lands and forests, powers related to non-renewable resources. These were actually added a few decades ago. Powers related to property and civil rights, matters of a purely local nature. And then through provincial powers, there are delegations of authority to municipalities in terms of exercise of local government, which is also an extremely important order of government here in Canada. And then the provinces may adopt the federal water quality objectives. And as I said, I'll speak about that in a moment. Next slide. So I'm just going to single out a couple of pieces of key legislation federally and then provincially in the case of Ontario. Um, in the case of the Canadian federal government, one of the most important water protection laws, interestingly, is the Fisheries Act. And it doesn't sound at first blush that this would be the key water protection law, but the reason is that it includes a prohibition on discharges of substances deleterious to fish. And this is has been proven with case law to be more stringent than, for example, in the province of Ontario, our provincial analogous law, which I'll talk about next. So, for example, under the Fisheries Act is a place where we set regulations that may apply to different sectors, including the wastewater systems effluent regulations. And this becomes quite important in terms of protecting water quality and protecting aquatic life in Canadian inland waters. And under those regulations, municipalities or other sectors are required at the moment to be upgrading their wastewater systems to meet more stringent standards over the next several years and better protect the freshwater environment from the impact of those effluents. Of course, those systems are often owned and maintained by the municipal governments, and they're licensed by the province with additional requirements I'll talk about momentarily. So it's a very complex interjurisdictional interplay going on in terms of how the legislation applies on the ground. Another key piece of federal legislation that I'll single out right now is the Canadian Environmental Protection Act. And under this piece of legislation, which does include a general pollution prohibition, we have regulations and empowering provisions, among which include the sections setting up the National Pollutant Release Inventory. And this is akin to the TRI, the Toxic Release Inventory in the United States. And you may recall that the three jurisdictions, Mexico, the US, and Canada, together report on the major emissions from their major emitters annually in a report called Taking Stock. And so SEPA is the place where that inventory is set up. And the reason I mention it here is because it specifically requires the major emitters of listed pollutants to report on their emissions to various media. So to air, as you saw when I spoke a few moments ago about pollution emissions that impact vulnerable communities, but also importantly to land, which may have some impact to groundwater and or surface water, and then directly to water. So those emissions from those large emitters are reported and publicly available, searchable. And as I mentioned, we have updated mapping coming up for the province of Ontario quite soon to talk about where we sit with those releases. Next slide. And then in Ontario, we have a few pieces I'll pull out right now. One is the Ontario Water Resources Act. And under that legislation, there's a general prohibition on water discharges that may impair the quality of water. Um, and there are additional provisions that provide that a facility may obtain a permit that allows them to emit to water. And in doing so, they need to seek that permit from the Ministry of Environment and Parks in Environment Conservation and Parks in Ontario. And notices are provided on the Ontario Environmental Bill of Rights, so the public receives notice of these applications and can provide input into whether they should be granted or not, or whether the terms should be altered. I won't get more into the EBR, but there are appeal rights both for the facilities and for the public under that law. In terms of permits to take water, this is water quantity provision. There are many water quantity provisions that I'm not really getting into today, but just to mention that's where that sort of permit is found in Ontario, is under that same legislation, and is also the place where the Great Lakes water quantity agreement that was reached between the 8 Great Lakes states and the 2 Canadian provinces was embodied in Canadian law. So then under the Ontario Water Resources Act are provisions for permits for wastewater and stormwater facilities in terms of point source emissions to water. And the question about how those standards are set, I actually should not call them standards. They're set on a facility by facility basis, taking account of Ontario water quality objectives for fresh water. And there are calculations done, and there are some specific calculations that are done for specific receiving waters and specific water bodies. For example, Lake Simcoe, where there are requirements to control the emission of phosphorus, for example, in that water body. But there are no province-wide standards that apply to all facilities in the province, though rather they're set based on the type of receiving body, whether it's a river or a lake. And similarly, on a policy basis in Northern and Eastern Ontario, there may be additional restrictions included in the calculations for water more generally, apart from the very stringent requirements for Lake Simcoe. I'll say more on nutrients later in the presentation. In terms of stormwater, non-point stormwater, so meaning flow over land, there are not specific regulations. Rather, they may be taken into account in terms of assessment on land use applications, for example, by way of the conservation authorities in Ontario, which are set up under the Ontario Conservations Act, providing comment to their constituent municipalities about the effect of a development and the amount of hard surfaces it may contain, for example, or about the extent to which it may impact the buffering ability of riparian zones on the water bodies. The other key legislation in Ontario is the Environmental Protection Act. Contains a general prohibition on pollution, but again, a permitting provision, but does include enforcement provisions, which are sometimes used for water offenses in addition to the Ontario Water Resources Act. Now, both of them contain exceptions for what are termed normal farm practices, and there's separate adjudication under something called the Normal Farm Practices Board when there is an allegation that a farm practice is impacting water or the environment. And if it's a normal farm practice, then it is exempted from those enforcement provisions, unless it falls under the nutrient regulations we'll get into later. Next slide. So in terms of standards and guidance, um, I mentioned a moment ago that I shouldn't refer to the Ontario Water Quality Objectives as standards because they're not, they're guidance. So that is something that perhaps we could think we're missing to some extent is minimum standards, although there are arguments in favor of the facility-specific approach as well as the broader minimum standards. Um, so the way that standards or guidance are established is that, first of all, because we're a federation, there's a body called the Canadian Council of Ministers of the Environment, and all of the environmental laws have provisions for interjurisdictional cooperation like this. So they take on the study of particular contaminants or pollutants and from time to time revisit and review those matters, do a scientific paper, put it out for comment, and then arrive at a consensus-based indication of the recommended guidance for the particular pollutant or contaminant or chemical or radionuclide, as the case may be. And then the provinces, so I should say, for federal matters, then they would apply those numerical guidance as standards or as guidance, either for federal lands or for any decision making they might exercise over Indigenous lands, like on reserve, um, and military lands would be another example. But otherwise, it's up to the province and territory to decide to adopt those guidance numerical recommendations in their jurisdiction, either as guidance in their own right, like in the province with water quality objectives on the surface freshwater side, or in the case of drinking water, which I'll say more about in a moment, as actual standards. And the role of guidance documents is that it impacts the decisions being made on the specific permits or certificates being issued for specific facilities, um, and means that in general, the decision makers will pay close attention to those guidance documents in determining what the binding numerical requirements are for that particular emission permit or certificate, as the case may be. In the case of permits and certificates, once they're issued, then they become binding on the recipient, on the operator of that facility, whether it be a wastewater facility or a manufacturing facility. Next slide. So we'll do a case study in terms of Ontario's drinking water laws. And I should mention that my organization had been calling for a Safe Drinking Water Act since the mid-1970s. The United States had adopted such a federal law in 1974. And on the whole, there was no interest in Canada or in the provinces to adopt a drinking water law. And many felt that drinking water was adequately protected, especially groundwater, felt that it was quite safe. And while there were requirements for disinfection of groundwater when used for municipal supply, this was not universally perceived as essential, even when it was required. Ontario previously had drinking water guidelines only, as did most of the provinces in the rest of the country, and there were no binding standards. In addition, the responsibility for providing safe water was not clearly articulated, and pre 2000, the only real authority, oddly enough, was with the medical officer of health, which had become rarely used, and there were very few health unit resources spent on drinking water. But the reason that authority was with the medical officer of health was because back in the days when it was first understood around the turn of the previous century that there were issues like cholera that were mediated by contaminated drinking water. That was what prompted the formation of public health units in, for example, Ontario. And so, although that was how they got their start, their attention to that had really vanished by the year 2000 in favor of regulation by the Ministry of the Environment of drinking water facilities. And as I mentioned, these guidance documents as opposed to standards. Next slide. So in the year 2000, tragedy struck the small town of Walkerton, Ontario, on the way up to the Bruce Peninsula um, uh, near the shore of Lake Huron and Georgian Bay, in between Lake Huron and Georgian Bay, where torrential rains struck and, among other things, caused flow from a manure storage facility on a farm nearby to a vulnerable municipal well. That farmer did not appreciate that his farm was right beside a municipal well because no one had ever told him so. And he was actually practicing what at the time was a best practice, where he had a cement pad under his manure storage. But unfortunately, there were a number of other coinciding factors occurring. Um, the well was not being chlorinated because the chlorinator had broken down, and the operators continued to operate the well without chlorination. There had been adverse results that the operators didn't pay adequate attention to. There had been recent provincial budget cuts to the Ministry of the Environment, which oversaw drinking water as well as privatization of the labs that took the drinking water results. There was a lack of awareness by the new private labs that they should inform health officials or environmental officials if there were adverse drinking water results in any of their customers' tests. And as I mentioned already, the legal responsibility was very poorly defined. Um, the operators, many of them had little knowledge that drinking water was a health threat. Um, Subsequently, there was an inquiry, and many testified to that effect, including some of the environment and health officials. And land use planning at the time was not adequate to control these kinds of risks to drinking water. So as a result, the drinking water source in Walkerton became badly contaminated with E. coli 0157H7, Campylobacter, and other pathogens. The town population of about 5,000 people had about 3,000 people very seriously ill, children being helicoptered to the London Health Sciences Centre, and it wasn't immediately obvious to anyone that it was because of the drinking water. It was eventually within a few days ascertained by the epidemiology and sleuthing of the health unit, but the operator of the lab in the meantime was actively hiding the adverse results that had come back. So 7 people died from that incident, including a 2-year-old child. And as I mentioned, it was followed by an inquiry. Next slide. So at that inquiry, provincial public inquiry, my organization represented the concerned Walkerton citizens. It was a lengthy 2-part inquiry, and it delved into what had caused the tragedy at Walkerton, as well as recommendations to make sure it wouldn't occur again. The result was a multi-barrier approach to drinking water protection as the recommendation, which was an approach we had advocated for our clients, and so had the water treatment industry. And in the next provincial election, all of the political parties promised to implement all of the inquiry's recommendations. Next slide. So Ontario, as a province now, has a very thorough protective framework, setting up this multi-barrier protection framework, like the Safe Drinking Water Act, which was introduced soon after the tragedy occurred to establish drinking water standards instead of guidance, mandatory water treatment requirements, training and certification around operators and labs and drinking water systems, specific oversight requirements on the part of environment and health officials. It set up new duties of care for municipal councillors who are now obligated to actively inquire into the uh, state of health of their drinking water systems, um, specific requirements about what happens if there's an adverse event, including public notification, uh, explicit requirements for transparency and disclosure of information to the public, and extensive monitoring right from the source water through the distribution system. Next slide. So the first barrier in that multi-barrier approach that I mentioned is source water protection. That's been established by way of the Clean Water Act, which is new legislation as of 2006, set up source protection regions and committees around the province, and they established geographically specific source water protection plans that must be approved by the province, as well as an extensive set of rules about how both intake zones for groundwater and surface water must be kept safe within a certain time of travel or water flow. However, there are still major gaps with the framework, and many small municipal systems, small towns on non-municipal systems, and First Nations are not adequately covered yet by water protection laws in Ontario, and nor is the rest of the safety net in terms of monitoring and treatment and distribution. And even when the rest of those matters may not be applicable, such as a town of a few thousand people who all have their own wells and septic systems, we contend they still should have the benefit of source water protection. Next slide. Other things that were done in the wake of the Walkerton tragedy were to establish the Walkerton Clean Water Center, and that established groundbreaking training for Indigenous water operators, including into the near and far north, called circuit training. And what that meant is that the training went to them because a lot of those operators could not leave their communities to go for training because there wasn't someone else available to run their system. The Ontario Drinking Water Advisory Council was also set up specifically reporting to the minister to keep it separate from the civil service to some extent, to give independent advice on drinking water standards. And the Public Health Protection and Promotion Act was amended to give powers for medical officers of health and health inspectors to protect small non-municipal systems that serve the public, like camps or a gas station out in a rural corner. And there also is a regulation under the Ontario Water Resources Act, the governs wells, Regulation 903, that provides some protection for the drilling of drinking water wells for private landowners, such as recording those wells, their location, their depth, and disinfection. But we're still looking for major improvements to those regulations in Ontario. Next slide. And then federally, as I mentioned, Canada publishes guidelines, which do include drinking water guidelines specifically. And those include input from provinces and territories, and they do that by way of putting out white papers for public input. Then, as I mentioned, even though it's consensus decision making where the provinces and territories are at the table, they nevertheless go back to their jurisdictions and decide which of them to adopt, and they could be more stringent or less stringent than those Canadian guidelines. And I mentioned already they can be applied or are applied by Canada in respect of its areas of jurisdiction. And then right now, there is a Safe Drinking Water for First Nations Act that was enacted several years ago but not implemented. And there are active consultations about replacing it with a new framework. So in the meantime, First Nations drinking water systems, which did have several hundred under perpetual boil water advisories, are now, I understand, down to about 3 dozen. um, but still a major problem that needs to be rectified, and operating with the various funding agreements. And so the federal budget in Canada um, stated that the new legislation will be in place this year, and I'm hopeful that that will be true. Next slide. There's a specific water quality issue dealing with nutrients, so phosphorus, nitrogen, and because the Walkerton tragedy had been um, caused by the overflow of uh, manure from cows, there was a push within the provincial government in Ontario to enact a Nutrient Management Act. And that was passed in 2002, fairly soon after the tragedy and right after the Walkerton inquiry. And there had been discussion with the province uh, aiming at such legislation in the past, but it hadn't moved ahead. So it did move ahead at this time. And it's a regulatory scheme that provides for nutrient management plans and nutrient management strategies. And there are a variety of entities that have to develop the plans and strategies, such as large animal farms or municipalities with biosolids from their sewer sludge. And there are specific rules provided in that legislation and its extensive regulations regarding application of nutrients to land, such as application on slopes, on frozen soils, what types of containers can hold different types of nutrients, provisions for anaerobic digesters and other related issues. But it's still, I would say, very intractable in Ontario. Nutrients are still a major concern. Water body like Lake Erie, Lake Simcoe, I mentioned already, as well as some significant sections within Lake Huron, Lake Ontario, and many inland lakes still have severe problems with nutrients. And nitrates in groundwater are increasing in some areas of the province, such as southwest Ontario, with high agricultural activity and a lot of sand and gravel. Next slide. So that brings us to the end of this presentation. I hope it's been informative, and the Canadian Environmental Law Association includes among our mandates public legal education, like this presentation, advocating for improvement to law, providing services to our client communities, and we'd be very happy to answer questions if you wanted to communicate with us at any of the mechanisms shown on the slide. And I wish you all the best with your meeting. Thank you very much.